Chambers. The Senate is back in session, and we will return to the Senate third reading file. We are at file item 67. Senator Steinberg, are you prepared to take this item up? And members, we will return to the beginning of today's third reading file after a first pass to see if there are any outstanding issues. We are at file item 67. Senator Steinberg, are you prepared to take this item up?
Yes, I am.
Then we'll ask for Secretary to please read.
Senate Bill 52 by Senator Steinberg, an act relating to environmental quality and declaring the urge thereof to take effect immediately.
Thank you very much, Mr. President. This bill is a cleanup bill to AB 900 of last year, which created significant new CEQA streamlining for environmental leadership projects. The bill fixes some erroneous language, some incorrect timelines, and other technical flaws with the original legislation in order to ensure the process now in the law works smoothly. I've had some significant conversations with, I know, Senator Huff and some of my Republican colleagues about what we might do regarding more substantive changes to SB 900. For example, the issue of whether or not we ought to allow, AB 900, ought to allow projects which have already begun their environmental process to qualify for the expedited process. And I know Senator Kehoe can speak to this if it comes up, but I have asked Senator Kehoe to chair an informal working group that will include Senator Lowenthal, Senator Berryhill, and Senator Blakesley to look at the substantive issues and to recommend to the leadership on both sides of the aisle how we might make AB 900 of last year an even more significant piece of legislation. It would be my intent, once those recommendations come back, to put those recommendations into a separate piece of legislation that could be authored by any member of the body. I certainly don't need to author it. This bill itself is merely the technical cleanup. I urge that the members on both sides support it so that we can clean up AB 900 and allow Senator Kehoe in a bipartisan manner with Senators Blakesley and Berryhill to report back, and then let's begin work on actually improving the substantive work product. Long explanation, but I urge an aye vote on this technical piece of legislation.
Members, is there debate or discussion on this item? Debate or discussion? Senator Berryhill.
Mr. President and members, I realize that I am on the conference committee, but I am going to rise in opposition of this bill today, and there are several reasons why I do so. I oppose this measure because I cannot let this become the extent of the major CEQA reform that this body achieves. We can do better, and we did do better just this last year in the negotiations with the governor. As a member of the GOP 5, which brought the necessity of CEQA reform to the forefront in last year's budget debate, it's obvious that this caucus, and certainly myself, is in support of major, real CEQA reform. However, this bill certainly isn't CEQA reform. This is a cynical attempt by the majority to slip a few minor changes under the cloak of CEQA reform. This bill does not address the issue of the out-of-control attorney's fees, which are crippling our businesses and selling job-creating projects. This bill certainly does not address the issue of document dropping, which we had negotiated last year, a common ploy used by attorneys to drag out the CEQA review process, racking up attorneys' fees and causing unending delays to projects. And this bill certainly does not streamline the permitting process so that our small businesses are not caught up in the bureaucratic nightmares that send them scurrying to other states. There is plenty else this bill fails to even attempt. Now, folks, make no mistake, this bill may sound good, This bill may make a few changes, and in fact, it does. But this bill does not come close to making the changes necessary to reform CEQA and get Californians working again. Just doesn't. I can't support this bill because I cannot stand by while those who oppose real CEQA reform pass this fraud and then break their arms, patting themselves on the back, claiming they have accomplished reforms and created jobs. And that's what we're going to end up with at the end of this process. We must say no to this cynical attempt to shut the door on real reforms, which we're doing, and then let's get back to work on real CEQA reforms that are necessary to get Californians back to work again. I urge a no or not vote.
Further debate or discussion? Senator Evans.
Thank you, Mr. President. I simply wanted to briefly note that I voted against the original AB 900 last year, and consistent with my position on AB 900, I will be voting against this bill as well.
Senator Kehoe.
Thank you, Mr. President. I rise to urge your strong support for this bill. It is a technical cleanup to a bill that was debated very carefully last year, that had widespread state review and publicity on the editorial pages from Northern to Southern California. Can everything that we want to do on streamlining CEQA be done in one bill? No. We have, in discussions in committee and in private discussions talking to members here, generally agreed that there's some priorities that could be determined to be described as cleanup, more substantive changes, and then big picture changes. Senator Steinberg today is moving only the technical changes to AB 900. Further review of the CEQA process, of green building standards, of projects around the state, of project timelines are, we agreed, to be taken up by the working group, which meets today and will meet each week for the next 3 weeks. So there is lots to do, and one of the steps is passing SB 52 today, so I urge your support.
Members, do we have further debate or discussion? Senator Calderon, for what purpose do you rise, sir? To speak to this item?
Yes.
Please proceed.
Thank you, Mr. President. I just wanted to say I appreciate our colleagues on the other side of the aisle wanting to see more reform, more streamlining, as I do. And as you all know, we passed some groundbreaking reform last year on SB 617 and some other larger projects that speed up the judiciary process, projects that will be employing a lot of people in the state. And I plan on introducing more streamlining, one-stop shop permitting, and similar types of legislation this year. But everybody needs to understand that CEQA is a product of case law. Most of the CEQA requirements that we have to follow are results of decisions that judges made in court battles. So you just cannot go in and change judicial decisions. You have to do it by way of streamlining regulations, speeding up the process, providing incentives to move these projects along a lot quicker. This is actually an example of what we can do to make a difference, and that is doing some cleanup that helps speed the and streamline the regulatory process. So I urge all of you, as well as Mr. Berryhill and others on the other side of the aisle, to support this bill today. Thank you.
Is there further debate or discussion? Further debate or discussion? Seeing and hearing none, Senator Steinberg, you may close.
Thank you. I certainly don't want to make this over-dramatic in any ways, and colleagues on the other side of the aisle, Senator Berryhill, others, you're obviously free to vote your conscience and whatever you choose, but I just might suggest a couple of things. Number one, let's step back for a moment and remember that AB 900 of last year was a bipartisan initiative started by myself, the Democrat, to try to build upon the LA football stadium issue to say that if it's good enough for one project, it ought to be good enough for more projects, and we need to get this economy going. Most of you supported it. Some of you said, well, maybe it doesn't go far enough. You'd like to do other things. Okay. So it passed, and it was signed by the governor. Now we're back. And as I've represented, we're now, what, in the 4th week of session. It is a technical cleanup bill to make sure that it works. I have acknowledged and said publicly that there are a whole host of other issues that we want to deal with in a positive way. Senator Kehoe has agreed to chair a working group. Senator Huff has asked me to appoint you and Senator Berryhill and Senator Blakesley to that same working group. I said fine. There's an appropriate time in this process. You know, I know it's a word we don't use, you know, we don't say too often. There's appropriate time to exercise leverage and to sort of make your point. I would just might suggest to you respectfully that I'm not sure that this is the time in the process to make a stand here. We're in the 4th week. We want to work on these issues. We suggested AB 900 in the first place. And so if you don't want to vote for this, I then drop the urgency clause. The bill passes, and it just slows down the implementation of a law which everyone agrees is a step in the right direction. So, okay, I'd urge an aye vote, but I'm prepared to live with whatever the outcome is. Thank you.
Mr. Secretary, please call the roll.
Alquist. Aye. Anderson. No. Berryhill. No. Blakesley. Calderon. Aye. Canella. Corbett. Aye. Correa. Aye. De Leon. Tessanier. Aye. Dutton. Emerson. Evans. No. Fuller. Gaines. Hancock. Aye. Harmon. Hernandez. Aye. Huff. Kehoe. Aye. Leno. Aye. Lamalfa. No. Ted Lieu. Aye. Carol Lieu. Aye. Lowenthal. Aye. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. Aye. Runner. Semidian. Aye. Steinberg. Aye. Strickland. Vargas. Aye. Walters. Wolk. Aye. Wright. Aye. Wyland. Yee. Yee. Aye.
Call the absent members.
Blakesley. Canella. De Leon. Aye. Dutton. Emerson. Fuller. Gaines. Harmon. Huff. Runner. Strickland. Walters. Wyland.
Ayes 24, noes 4 on the urgency. The urgency fails. Senator Steinberg,
Thank
for
you.
what purpose do you rise?
Thank you, Mr. President. Pursuant to Joint Rule 23.5, I'd like to amend out the urgency clause, and then I'd like to, once that's done, without objection, I'd like to take the bill up in mock-up form. Thank you.
Without objection, the amendments are adopted, stripping the urgency from the bill.
We're passing out the mock-up right now.
There is no objection. The amendments are approved. There is a mock-up being handed out on the floor of the Senate now, members, which consists of the bill absent the urgency clause, which Senator Steinberg has stricken from the bill. The bill is now before us. This is file item 67. It is Senate Bill 52 without the urgency clause. It is now a 21-vote bill, and we will ask the Secretary to please read.
Senate Bill 52 by Senator Steinberg, an act relating to environmental quality.
Senator Steinberg?
Same bill, same merits, no urgency. Urgent aye vote.
Further debate or discussion? Senator Blakesley.
Thank you, Mr. President Pro Tem. I want to thank the author for his hard work. We're very grateful that the measure is alive and moving forward. Looking forward to participating on the working group to ensure this bill can be implemented in a thoughtful way. I would urge an aye vote.
Further debate or discussion? Further debate or discussion? Seeing and hearing none, Senator Steinberg, you may close.
Well, let me appreciate Senator Blakesley's gracious comments and, of course, urge an aye vote. But let's think about what the end result of this will be. Apparently, there will be 27 votes or more on the bill, which means it'll pass. But because I had to strip the urgency, that will mean that this important CEQA reform, its cleanup, will not go into effect earlier than it could have. I'm not quite sure of the logic of the end result, but I'm very happy to live with whatever the will of the body is and urge an aye vote on the measure. Thank you.
Thank you, Senator. Secretary, call the roll.
Alquist. Aye. Anderson. No. Berryhill. No. Blakesley. Aye. Calderon. Aye. Canella. Aye. Corbett. Aye. Correa. Aye. De Leon. Aye. DeSaulnier. Aye. Dutton. Emerson. Evans. No. Fuller. No. Gaines. Aye. Hancock. Aye. Harmon. Aye. Hernandez. Aye. Huff. Aye. Kehoe. Aye. LaMalfa. Leno. Aye. Ted Lieu. Aye. Carol Lieu. Aye. Lowenthal. Aye. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. Aye. Runner. Semidian. Aye. Steinberg. Aye. Strickland. Aye. Vargas. Aye. Walters. Wolk. Aye. Wright. Aye. Wyland. Yee. Yee, aye.
Mr. Secretary, please call the absent members.
Dutton. Emerson. Aye. LaMalfa. Aye. Runner. Walters. Wyland.
Ayes 32, noes 4. The bill is passed. Members, before we proceed, could I have the attention of the House, please? Before we proceed, members, I would like to read briefly from Mason's Manual of Legislative Procedure. This is Section 123, subsection 1. No person may indulge in personalities, impugn motives of members, or use indecent or profane language. Once again, no person may indulge in personalities, impugn motives of members, or use indecent or profane language. The injunction of Mason's Manual is that we speak to the merits of the measure before the body and not the motives of any individual or collective group of members. I would respectfully request that members keep that in mind as we continue with the debate on the floor today. That takes us to file item 68. Senator Steinberg, are you prepared to take this item up? Mr. Secretary, please read.
Senate Bill 654 by Senator Steinberg, enacting to redevelopment and declaring the urge thereof to take effect immediately.
Thank you very much, Mr. President. This bill, which passed unanimously with Democratic and Republican support through the Senate committees, is an urgency measure which allows cities and counties to preserve for affordable housing purposes the roughly $1.4 billion in outstanding balances in the low and moderate income housing funds maintained by the 400 redevelopment agencies throughout the state. I would urge an aye vote on, again, a bipartisan measure which will provide our cities some much needed relief in this area. And to state, I think, the obvious, without belaboring it, this is not the end of the economic development debate as it applies to local government, but an important piece of the puzzle. I look forward to working with my colleagues on both sides of the aisle to recreate robust economic development tools for local government. urge an aye vote so that there's not a delay in putting these important dollars to use in our local communities. Thank you.
Debate or discussion on this item? Debate or discussion? Senator Huff.
Mr. President, I have amendments at the desk on this bill.
Thank you, Senator Huff.
I would like to move those.
Thank you. Members, the measure before us is file item 68. This is Senate Bill 654 by Senator Steinberg. Senator Huff has risen to announce that there are amendments at the desk. We will ask the Secretary to please read the amendments which have just arrived at the desk.
Amendments by Senator Huff, set 1.
Perhaps you'd care to elaborate, Senator Huff.
Yes, I would. Redevelopment as we know it is dead. And there has been significant collateral damage to cities, local government, as they try to figure out what 60 years, 70 years of policy has been accomplished through this, how that we unravel that in a way. So these amendments are something that come to us from our cities. They're backed by the Redevelopment Association, by the League of California Cities, by the client cities of the Gonzaleses. Those are involved in city issues as a way to soften the fall as the corpse has fallen and is going to hit the ground. Because there's many, in the haste that we did it, there's many unintended consequences and a lot of legal issues that need to be clarified. So this has been drawn up to try to help soften that fall. But make no mistake, this is not about extending redevelopment. It's not about reinventing redevelopment. It's trying to have less collateral damage to local government through the actions that we took while we were in session last. As we know, the body passed AB 26X, AB 27X. We told agencies we weren't ending redevelopment, we were mending it. Well, we did end it because the Supreme Court found that the pay-to-play provisions in AB 27X were unconstitutional. And so we must now act in a way that wasn't considered then to address those unanswered questions that were contained in AB 26X. So I appreciate what the pro tem's desire to address affordable housing, but we must go further. It's not just about that. What about the hundreds of millions of dollars to legitimate city-to-agency loans? I'm sure if you've heard from your cities, you've heard about a lot of these issues that I'm talking about. What about the daily downgrading of municipal bond ratings that one of our members talked of last week? What about the thousands of jobs we've now put into limbo as they try to sort out, what's the ramifications? Is this project going forward that's encumbered and contractually? Does it not? And there's so many other issues. Members, let's be clear. Agencies are eliminated tomorrow. The funeral proceedings are before us. Now is the time to act. We have laid redevelopment agencies on the table. They go into the wall tomorrow. We can't afford to simply lay these amendments on the table, which is normal what happens when a Republican issues amendments. So I just encourage you, do what's best for your local communities. Hopefully you have been listening to them. You know the collateral damage that happens absent legislative action from us. I have before us what I believe answers some of those questions, and certainly we will be figuring out other stuff as we go. This helps soften the fall, and I respectfully ask you to support these amendments.
Debate or discussion? Senator Corbett.
Thank you, Mr. President. I'd like to move to lay these amendments on the table.
Motion to lay on the table. Members, this requires a majority of those present and voting. Senator Corbett is asking for an aye vote for the motion to lay on the table. Senator Huff, I believe you are asking for a no vote on the motion to lay on the table. Mr. Secretary, please call the roll.
Alquist. Aye. Anderson. No. Berryhill. No. Blakesley. No. Calderon. Aye. Canella. No. Corbett. Aye. Correa. Aye. De Leon. Aye. DeSaulnier. Aye. Dutton. No. Emerson. No. Evans. Aye. Fuller. No. Gaines. No. Hancock. Aye. Harmon. No. Hernandez. Aye. Huff. No. Kehoe. Aye. LaMalfa. No. Leno. Aye. Ted Lieu. Aye. Carol Lieu. Aye. Lowenthal. Negrete McLeod. Aye. Aye. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. Aye. Runner. Semidian. Aye. Steinberg. Aye. Strickland. No. Vargas. Aye. Walters. Wolk. Aye. Wright. Wyland. Yee. Yee, aye.
Call the absent members.
Lowenthal. Runner. Walters. Wright. Wyland. Lowenthal, aye.
Ayes 24, noes 12. The amendments are tabled. Members, we return now to the bill in chief. We are at file item 68, Senate Bill 654. Is there additional debate or discussion? Additional debate or discussion? If not, Senator Steinberg, you may close on this measure.
The question before the House, Mr. President, is simply whether or not we get this money to our cities sooner rather than later. It takes a 2/3 vote to get it to them sooner. I urge an aye vote.
Mr. Secretary, please call the roll.
Alquist. Aye. Anderson. No. Berryhill. Blakesley. Calderon. Aye. Cannella. Corbett. Aye. Correa. Aye. De Leon. Aye. DeSaulnier. Aye. Dutton. Emerson. Evans. Aye. Fuller. Gaines. Hancock. Aye. Harmon. Hernandez. Aye. Huff. Kehoe. Aye. LaMalfa. Leno. Aye. Tedlew. Aye. Carolou. Aye. Lowenthal. Aye. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. Aye. Runner. Semidian.
Aye.
Aye. Steinberg. Aye. Strickland. Vargas. Aye. Walters. Wolk. Aye. Wright. Wyland. Yee. Yee, aye.
Call the absent members.
Berryhill. Blakesley. Cannella. Dutton. Emerson. Fuller. Gaines. Harmon. Huff. LaMalfa. Runner. Strickland. Walters. Wright. Wyland.
Ayes 24, noes 1. Senator Steinberg moves a call.
I will move a call.
Thank you. Members, that takes us to our next file item. That is file item 69. Senator Leno, are you prepared to take that item up? Pass temporarily. File item 70. Senator Leno, are you prepared to take that item up? Pass on file. File item 71. Senator Kehoe, would you like to take this item up? If so, we'll ask the Secretary to please read.
Senate Bill 730 by Senator Kehoe, an act relating to the payment of claims against the state, making an appropriation therefore, and declaring the urge thereof to take effect immediately.
Thank you, Mr. President. Members, this bill is one of our customary claims bills. It is sponsored by California Department of Justice. It appropriates $13 million from the general fund and the Department of Parks and Recreation to pay 5 claims. The Department of Finance supports the measure. These are claims on lawsuits that we have not lost. We have lost, but we have significantly reduced the amount of money asked for. Up until this morning, there was no opposition, but I think we're going to hear from some now. But I think it's very important that we honor the decisions that are made by the courts and allow the state to go forward with making claims to people who have prevailed in court. I respectfully ask for your aye vote.
Is there debate or discussion? Debate or discussion? Senator Anderson.
I have submitted an amendment to this bill, and I'd like to take up the amendment now if possible.
One moment, please. Let me confirm that we have amendments at the desk. We do. Secretary, please read.
Amendments by Senator Anderson, set 1.
Senator Anderson, you may speak to the amendments.
I'd like to vote for this bill. I'm having difficulty because one of the items is a payout of over $5 million. And I've asked that we separate that out from the other parts of the bill so that I may support this bill. I'd like to support it. But I have difficulty with that section. And after this amendment's been tabled and killed, then I thought I'd address it in the general bill. But one section that when we're paying off the Environmental Protection Information Center, I find objectionable. Thank you.
Members, debate or discussion on the motion to amend. Senator Corbett.
Yes, Mr. President, I'd like to move to lay these amendments on the table, and I ask for an aye vote on that motion.
Motion by Senator Corbett to table the amendments. Senator Corbett is asking for an aye vote. Senator Huff, I believe you're asking for a no vote. Mr. Secretary, please call the roll. Members, this is on the motion to table. It requires a majority of those voting and present.
Alquist. Aye. Anderson.
No.
No. Berryhill. No. Blakesley. No. Calderon. Aye. Canella. No. Corbett. Aye. Correa. Aye. De Leon. Aye. DeSaulnier. Aye. Dutton. Emerson. No. Evans. Aye. Fuller. No. Gaines. No. Hancock. Aye. Harmon. No. Hernandez. Aye. Huff. No. Kehoe. Aye. LaMalfa. No. Leno. Aye. Ted Lieu. Aye. Carol Lieu. Aye. Lowenthal. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. Aye. Runner. Semidian. Steinberg. Aye. Strickland. No. Vargas. Aye. Walters. Wolk. Aye. Wright. Wyland. Yee. Yee. Aye. Semidian. Aye. Dutton. No. Lowenthal. Runner. Walters. Wright. Wyland.
23.
Move the call.
Members, this is motion is on call. The motion before us is simply to lay the measure on the table, which requires a majority of those present and voting.
Lift the call.
Senator Kehoe lifts the call. Call the absent members.
Lowenthal. Runner. Walters. Wright. Wyland.
Ayes 23, noes 12. The motion to table is passed. The amendments are tabled. Members, we now return to the bill in chief, which is SB 730 by Senator Kehoe. Is there debate or discussion on the bill? Senator Anderson?
Yes.
It's in opposition of this bill. I was hoping that we could strip out the one portion so I could vote for the bill. But the difficulty I have is that we've empowered bureaucrats to make these decisions. This is over a $5 million claim. And while the author is correct that it's rather routine, that's the problem. It's too routine. There's no oversight whatsoever. The attorneys come to agreement, and then the judge rubber stamps it. I'd like to send this back to the judge to find out whether this is a reasonable amount that we're paying. I believe it to be unreasonable. Many of you may not join me in that belief. So for that reason, I won't be able to support it today. Thank you.
Further debate or discussion? Senator Harmon.
Thank you, Mr. President. I wanted to speak about one portion of the claim. It's the one that Senator Anderson mentioned. It's a very substantial claim. It's $5.5 million in attorney's fees. I wanted to give the members a little bit of a background overview about that particular lawsuit and how it came to the floor. This lawsuit is 13 years old. It was filed in 1999, and it dealt with plaintiffs that challenged certain permits and findings under the Environmental Quality Act. It basically involved timber harvest practices up in Humboldt County. The case went to trial, and the trial court ruled in favor of the plaintiffs. There was an appeal, and the Intermediate Appellate Court, Court of Appeals, ruled in favor of the state. There was a further appeal, and it went to the California Supreme Court, and the Supreme Court ruled in favor of the plaintiffs. That means the state lost the case. Under the statutes that are involved in this particular type of litigation, there's a provision for the payment of attorney's fees. The plaintiffs demanded $14 million in attorney's fees, and this settlement that is now before us, the state is recommending, and the plaintiffs have agreed to accept $5.5 million in attorney's fees plus interest. Now, the plus interest part is sort of interesting because, and by the way, there were two lawsuits, not one lawsuit. They were consolidated by the court. One lawsuit was brought by the Steelworkers of America union, and the other one brought by the Environmental Protection Information Center. So the two separate lawsuits got consolidated, went up through the trial and appellate process that I described. Then the agreement was reached on the attorney's fees, and that's really what's before us today. There was not a monetary judgment. It was injunctive relief seeking to have these permits, these logging permits, set aside. And the agreement calls for the payment of interest at 7% a year on the $5.5 million starting last November 11th. So we're to December, to January, now almost to February, almost 3 months of interest. The interest is running at $1,054.80 a day, according to my calculation. What happens when cases like this are settled? Usually somebody says, okay, I'll pay $5.5 million, and the check is, the settlement proceeds are made available within a matter of a few days or a week or 10 days. I'm sure other attorneys on the floor that have done this type of legal work are familiar with that process. But when it's the state of California, it has to go to the legislature, and there has to be an appropriation of that amount. So that's why there's this interest is tacked on, because the plaintiffs are sitting there saying, well, wait a minute, I've got to wait and wait and wait. And in fact, the agreement says that sometime during the legislative session of 2012, the state will appropriate this money. Well, here it is, and this is as quick as we could get it, given the circumstances of our schedules and the way things come to the floor. So I believe that given the choice between $14 million, which the plaintiffs are asking, and the $5.5 million plus interest that the state is offering to pay, it's a reasonable settlement under those circumstances, and for that reason, I urge an aye vote.
Is there further debate or discussion? Senator LaMalfa.
Thank you, Mr. President. I have to recount on the intention of Senator Anderson's amendment here. This would have separated the measures that are not objectionable to some of us here, the claims that we would gladly pay off, with this one here that has been just outlined. In recent years, the Environmental Protection Information Center brought lawsuits to the logging industry on the North Coast, and it's been many years, but it ended up with a settlement just to get them out of court, just to get it over with. It wasn't something that the court required, and indeed the DOJ just signed off on it in order to get it over with. So here we are, $5.5 million of taxpayer money, but even more so, we haven't done anything to reform litigation like this that can happen in California. One of these can be brought at any time, and yet we're going to be back in here in future years doing more litigation settlements, thinking that we're getting a good deal out of it. Instead of it being a higher number, we're only paying this amount to groups like EPIC to have more frivolous attorney fees paid off. So where are we going to draw the line? Where are we going to make a stand on this thing? And then when we're talking about settlements, where's a settlement for thousands of workers in California who've lost their jobs because of litigation like this against people that log or people that do farming, ranching, water users, any type of industry where somebody can just pop up with a lawsuit anytime and sue, and then you have to settle with them, and we think we're getting a good deal. This isn't a good deal, and until we reform the way things are done in California, I think we need to quit just going for settlements and paying it off and sending them on their merry way. I ask your no vote.
Is there further debate or discussion? Further debate or discussion? Seeing and hearing none, Senator Kehoe, you may close.
Thank you, Mr. President. I want to thank Senator Harman for a very careful and reasonable explanation of exactly what this one item is about. The suit went through the courts. The court ruled in favor of the plaintiffs. The state lost the suit, but in negotiations and settlement reduced the attorney costs from $14 million to a little over $5 million. This is something we owe the plaintiffs, along with all the other 4 settlements or so. And it is our obligation to pay it. It is our responsibility to pay them all, and the state should do so. That's why we're carrying this bill. I would ask for your aye vote.
Mr. Secretary, please call the roll.
Alquist. Aye. Anderson. No. Berryhill. Aye. Blakesley. Aye. Calderon. Aye. Canella. Aye. Corbett. Aye. Correa. Aye. De Leon. Aye. DeSaulnier. Aye. Dutton. No. Emerson. Aye. Evans. Aye. Fuller. Aye. Gaines. No. Hancock. Aye. Harman. Aye. Hernandez. Aye. Huff. Aye. Kehoe. Aye. LaMalfa. No. Leno. Aye. Ted Lieu. Aye. Carol Lieu. Aye. Lowenthal. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. Aye. Runner. Semidian.
Aye.
Aye. Steinberg. Aye. Strickland. No. Vargas. Aye. Walters. Wolk. Aye. Wright. Aye. Wyland. Yee. Yee, aye.
Please call the absent members.
Lowenthal, aye. Runner. Walters. Wyland.
Ayes 32, noes 5 on the urgency. Ayes 32, noes 5 on the bill. The bill is passed. Senator Steinberg, for what purpose do you rise?
Thank you, Mr. President. If we could please go back to Senate Bill 654. Appreciate it.
Members, this is file item 68. We're going to lift the call at this time. Is that?
We will lift the call. That's correct.
Thank you, Senator Steinberg. We are back at file item 68. Mr. Secretary, please call the absent members.
Berryhill. Blakesley. Canella. Dutton. Emerson. Fuller. Gaines. Harman. Huff. LaMalfa. Runner. Strickland. Walters. Wright. Wyland.
Ayes 24, noes 1 on the urgency. The urgency fails. Senator Steinberg, for what purpose do you rise?
Thank you, Mr. President. Pursuant to Joint Rule 23.5, I'd like to amend out the urgency clause, and once that is done, I'd like to take up the bill in mock-up form.
Thank you. Any objection to allowing the senator to amend? Seeing and hearing none, the amendments are adopted. Members, you have now before you file item 68, Senate Bill 654, stripped of the urgency clause. The rest of the bill remains. There should be a mock-up at your desk that is being handed out by staff. Senator Steinberg, do you wish to speak to the bill?
Yes, I do. Thank you very much, Mr. President.
I apologize, Senator Steinberg. Now that the bill has been stripped of the urgency, I do need to ask the Secretary to please read.
Senate Bill 654 by Senator Steinberg, an act relating to redevelopment.
Thank you very much, Mr. President. I'd like to just spend my moment explaining to the membership and the public the difference between this bill with an urgency and without an urgency clause. Economists have estimated, and I think it's an accepted figure, that for every $1 billion of public infrastructure investment, California creates 15,000 jobs. So as a result of this delay in passing and hopefully the governor signing this bill into law, we are delaying the potential creation or maintenance of some 24,000 high-wage jobs for Californians. Let me be clear, we will move this bill, I believe, off the floor today over to the Assembly, and then we will consider exercising our majority vote power pursuant to Proposition 25 and add this language to a budget trailer bill so that when the budget passes, it can in fact go into effect immediately. No final decision on that, but I just want to be clear to the housing advocates and the people concerned about this measure that that is an available option to the legislature, and we would intend to consider seriously using it. I urge an aye vote on this measure. Thank you.
Further debate or discussion? Further debate or discussion? Senator Huff.
Thank you, Mr. President. The time to be concerned about jobs that are related to redevelopment was before we executed it. What we have before us is a component of what we need to do to manage the outcome of killing redevelopment and the economic development that it has fostered for the last 60, 70 years. And the housing component, in many cases, the only affordable housing revenue stream that we have for communities. So yes, this is an important bill, and I will support it. But let's not just do a partial incremental thing. As we move this thing through, let's do the comprehensive type of fix as we've killed redevelopment to manage that outcome in a way that doesn't do the collateral damage to the local government that they're already going to experience. Let's manage the outcome. We have the ability to do that. I hope we can work cooperatively, not just both parties, but both houses, as we try to help soften the blow to local agencies. And I do ask for your aye vote.
Further debate or discussion? Seeing and hearing none, Senator Steinberg, you may close.
Thank you. Appreciate Senator Huff's comments. And facts are stubborn things. Not probably good to digress too much, but just suffice it to say that this legislature, in the last budget, essentially appropriated $1 billion a year to continue redevelopment throughout California. The League of California Cities and the redevelopment agencies filed a lawsuit challenging that cut. The Supreme Court concluded 2 weeks ago that the legislature's necessary elimination of redevelopment was valid, but our reconstitution, which would have given the agencies $1 billion a year, was not. All or nothing led to nothing. That's why we're here today. I'd urge an aye vote so at least this $1.4 billion of housing money can get out to local agencies. I wish it could get out sooner, but we'll do the best we can. Thank you. Urge an aye vote.
Secretary, call the roll.
Alquist. Aye. Anderson. No. Berryhill. Aye. Blakesley. Aye. Calderon. Aye. Canella. Aye. Corbett. Aye. Correa. Aye. De Leon. Aye. DeSaulnier. Aye. Dutton. Emerson. Aye. Evans. Aye. Fuller. Aye. Gaines. Aye. Hancock. Aye. Harmon. Aye. Hernandez. Aye. Huff. Aye. Kehoe. Aye. LaMalfa. Leno. Aye. Ted Lieu. Aye. Carol Lieu. Aye. Lowenthal. Aye. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. Aye. Runner. Smidian.
Aye.
Aye. Steinberg. Aye. Strickland. Aye. Vargas. Aye. Walters. Wolk. Aye. Wright. Wyland. Yee. Yee. Aye.
Please call the absent members.
Dutton. LaMalfa. Aye. Runner. Walters. Wright. Wyland.
Ayes 34, noes 1. The bill is passed. Members, we return to our place on the daily file. We left off with file item 71. That takes us to the last bill on the Senate third reading file, which is file item 72. Senator Leno, are you prepared to take this item up? And we'll ask the Secretary to please read. Mr. Secretary, before you begin, let me ask the House to come to order. Members, if we could bring the House to order, please. One moment, Mr. Secretary. Please read.
Senate Bill 890 by Senator Leno, an act relating to debt buyers.
Thank you, Mr. President. Colleagues, I appreciate your attention for just a few moments so I can address what is a relatively new issue to this body, one I did not know about before I took up authorship of this bill. Let me say from the outset, I believe that debtors should pay their creditors. Debtors should pay their bills. It's certainly how I live my life. I'm proud of the fact that I have a good credit or great credit rating, that aside from mortgages, I have minimal, if any, debt at all. And this bill is not in any way about protecting scofflaws. What it is about is ensuring that no one will have their wages or assets garnered, or no one will be sued for debt they never owed. And that's what this bill is about. So it's sponsored by our Attorney General, Kamala Harris, and I want to clarify that this is not about debt collection. Debt collection is when a creditor has a collector go out and get payment for a bill that is owed. This is about debt buying and selling, where it's now a multi-billion-dollar industry here in California and growing very rapidly, and in effect, it is virtually unregulated, and I'll explain what that is all about. So someone may buy up literally millions of dollars of debt for pennies on the dollar, and because there is no requirement that when that debt buyer goes to collect on these unpaid bills, that they have the right alleged debtor, that they have the right amount, or that they can document the amount that is owed, and that they can document that the debt has never been paid. So this is the situation we're trying to address. Under this bill, the debt buyer will have to have documentation when they come to you to pay the debt that they can prove it is you. That means they have the last 4 digits of your Social Security number, or they have the last 4 digits of your credit card on which this debt was placed, or that they have the number of the account from the store that you had the store account. Some proof. And that before they can go into court, they also must have all of this documentation, something they currently do not need. So imagine this for a business model. They know they don't have to document anything. They also know that 9 times out of 10, a debtor, an alleged debtor, will not show up in court to make their case, to defend themselves. And what can then happen is that there is a default judgment because you didn't show up in court to defend yourself. And with that default judgment, even though they had to prove nothing, they had to document not that they had the right person, not that they had the right amount, not that they had any history to the debt whatsoever. And sometimes these debts can be sold 8, 9, 10, 11, 12 times over. They go for this default judgment, and with it, they can garnish your wages and your assets. And there are thousands of cases where people have lost their bank accounts, their homes, their lives on a debt they never owed. In fact, the Federal Trade Commission states that this is the industry that garners the most complaints of all industries in the country, beyond cable companies, beyond cell phone people, beyond banks. No complaints greater than from these debt buyers and sellers. And so, just want to share with you that I have a friend from Southern California who suddenly, from out of nowhere, got a call from his employer that, unfortunately, his wages were going to be garnished. He thought it was a joke. He never heard of such a thing. He knew he had no outstanding debts, but in fact, his wages were being garnished. Now, my friend is of some means, so it didn't mean that he was living hand to mouth. But you can imagine, in the case of someone in this down economy, struggling to keep his or her home, struggling to keep his or her apartment, or his or her job, that this could be devastating, especially for a debt that is not even owed. And, of course, subsequently, after trying to unravel all of this, it was revealed that because the debt collector the debt buyer who bought this off of a long list, had never substantiated that he had the right person. There were no documentation of it, no documents proving that that was the right person at the right address with a social security number, anything. There was, and of course, never got the announcement or the proclamation saying you must be in court to defend yourself, because it went to the other address of the other person with whom he was confused. Never showed up in court. There was a default judgment, and the wages were garnished. This is what's going on. The business model is to get to court with no requirement to document anything and get the default judgment. That's a business model of a multi-billion-dollar industry. The good news I can share with you is that the debt buyer and debt seller associations have been working with my office and the Attorney General's office, again, the Attorney General being the sponsor of the bill, and we have reached an agreement, a negotiated agreement. And so we have neutralized their opposition. The amendments, clearly, given it was just agreed upon over the weekend, will be taken on the Assembly side. And as we do business around here, you have my public pronouncement that the bill clearly will not move forward without my pronouncement being honored in the Assembly, so that those amendments will be taken. And the amendments narrow the bill, the obligations of the industry, though we believe we still have a substantive bill, that we've not given away the store. And one of the requests by the industry, because, of course, we're talking about businesses that cross state lines, and there will be time to adjust to our change in law here, that the effective date will be July 1st, 2013. Also, we had attempted to change the statute of limitations, which is 4 years here in California. We've left that alone. That will not be changed. That was also part of the negotiated settlement. So that's where we are. I also need to just bring up what I consider a bit of a snafu, something I've never experienced here in the legislature in my 10 years. So we all negotiate on our bills. We all find amendments. We all, hopefully, in our best work, find agreement, especially when there is industry opposition. In this case, quite uncommonly, the lobbyist for the debt buyers and sellers and the association wouldn't take my word. And so they insisted that my office sign an agreement to the negotiated settlement. And the deputy from the Attorney General's office wrote up the agreement with all of the very detailed negotiated amendments. And I just want to read one brief paragraph from this letter, for which I apologize. I have to even bring this to your attention because, as I said, I wish we were never forced to sign this letter, that my word would have been good enough. But it says that the opponents of the bill, meaning the collector, debt buyers industry, the opponents of the bill, represented by the undersigned, agree to remove their opposition to this bill in advance of the floor vote, and will communicate to all members of the California Senate, beginning with, and then it lists 5 senators, Wright, Rubio, Padilla, Vargas, and Hernandez, at the request of the opposition, that their opposition, the industry's opposition, has been removed and the bill should be allowed to proceed to the Assembly. I have heard from some colleagues that they believe that this is unseemly, that there might be some sense of quid pro quo before a vote. I, as I say, wish we had never been forced to sign this. I'm here to say, figuratively and literally, we will throw away this letter. There's no need for it. You have my word. As the bill goes to the Assembly, it will only move forward with the agreed-upon, negotiated by both sides, settlement. So with all of that, I appreciate your indulgence in this little bit of snafu, and that I ask for your aye vote on what is a very important issue.
Further debate or discussion? Senator Correa.
Thank you, Mr. President. Senators, I rise in support of this measure, and I want to thank my colleague from San Francisco for bringing this measure forward. You know, we've had a lot of legislation to address the mortgage crisis, but I believe this is the first one to address debt collectors that I've seen in my career in this legislature. Let me say that my learned colleague from San Francisco touched upon my personal experience of having my own wages being garnished here in the legislature, and that was happened last year, as I might have told some of you. I remember getting a phone call from the Rules Committee, and I don't know who was more embarrassed, me or the person making the phone call, informing me that I had a lien on my paycheck for $5,000. Now, I have to confess that I do have 4 children. They're starting college, and things are a little bit tight, but I'm making my payments, believe it or not. And what was interesting is that over the last few years, I've been getting a lot of phone calls at home, people with my same last name. And about a few months ago, I got a phone call for somebody that owed for a car, $5,000, and I got a little irate with this individual and finally gave him the last 4 of my Social Security number to prove to them I was not that person that owed that money. You think they would have gone away? And of course, I got this phone call, the wages being garnished. So then what I did, like everybody else, did some due diligence. I called the agency that garnished my wages, a law firm in San Francisco, I believe. And I talked to them, found out that the person they were after had my last name, same city, but different first name, different Social Security number, and of course, was not me. But what's interesting, though, is this was a default judgment on me. Default means somebody had to have sued me, somebody had to have served me, and that means somebody goes to your house and physically serves you and signs under penalty that they have served you. And thus, they go to court and enter a default judgment against you. And I'm wondering to myself, how many more individuals are out there in the same situation? This is not about protecting those that owe a legitimate debt, but rather this is about keeping tabs on who actually owes the money and who does not. In my opinion, this is very important, although noble, and I think there's other work that can be done in this area. Strong step in protecting those in our society that, like all of us, work so hard to protect your reputation, your credit score, which of course are so important for us to operate in society. Again, I thank my colleague for bringing this effort forward, and I ask all of you for vote aye on this measure.
Further debate or discussion? Senator Dutton.
Yeah, Mr. President and members, I can appreciate the problem, with regards to debt and sometimes the tactics that are used to collect the debt. But I appreciate Senator Leno's explanation of these amendments that are to be taken up at a later date. That actually kind of goes to my concerns and my problems. Too many times we seem to be passing things out of the House, out of the Senate, incomplete and not ready for prime time. I think this is a case of one of these times. I certainly have nothing against trying to get the bodies, getting the principals together to come up with some type of agreement. Now, I wouldn't have thought to put it in writing. I'll have to explore that. But, I'm not sure how you'd enforce it anyway. But I am concerned that this bill isn't complete, and I'm concerned about what's going to happen coming back here. I no longer have an opportunity to participate, and we obviously don't participate in the assembly process when they're looking at this legislation. So while I appreciate the author's attempt to deal with a problem, I can't support this because it's not complete. And so I'll be opposing it. And I am also a little concerned about what happened here, if maybe we need to have some more orientation of staff and others so that this type of embarrassment doesn't happen to any member on the floor. So I would encourage a no vote.
Senator Wright.
Let me just say, I was not a party to the letter or what happened. I saw it today, and it had my name in it. I'm fully capable of causing trouble on my own when I really don't need assistance from other people. So I'm a little concerned with that. I mean, I don't know. Again, as Senator Leno mentioned, we normally say you'll take amendments and you move forward. So, I do want to assure the body that I was not the one who said that there needed to be a letter, and I don't think that my other colleagues who were also named in the letter were a party to that as well. I had some concerns when the bill was first presented, and it's clearly one of those issues where you can see it from both sides. As people lose their jobs, as the economy begins to crater, the number of people who default on judgments tends to grow. This is a business that in the world and my neighborhood, we call these bottom feeders. People who buy, in effect, what is bad paper and try to squeeze money out of a place that, perhaps wasn't going to be there. So whether it's a credit card debt or a doctor's office or whomever that might be, and you do hope, as Senator Leno mentioned, that they're shooting at the right person. I'm glad that they were able to work out some of the challenges, because just as there are people who make the error going after the wrong person, there are people who attempt to make debt and evade that debt, which at the end of the day reverts back to all of us because we pay for that, whether it's shoplifting or other kinds of fraud, we pay for that. When you hear someone says, I beat my insurance company, yeah, they did, but ultimately we all pay for those crimes when people beat them. So I'm prepared to support it today. I'm glad that they're working out the amendments that will give both parties a way to go. I think that there's some movement by Senator Leno and the other parties. That's kind of sort of what we do here. I'm concerned about being mentioned in a letter that I was not party to, and I want to say, again, as we would say in my neighborhood, my name is Bennett, and I wasn't in it. But that aside, I'd ask for an aye vote on SB 890.
Thank you, Senator. Senator Harman.
I don't know why I always have to follow Senator Wright. He makes these great comments. I rise in opposition. I too am concerned about the listing of Senators Wright and Rubio and Padilla and Vargas and Hernandez in a written document that says this is how they're going to vote, or they've removed their opposition, and they don't, according to what Senator Wright just said, didn't know anything about it. So that is certainly a concern of mine in how this bill was processed. But the thing that bothers me is this bill is not finished yet. It's why send it out of this House to have some work done in the other House where we don't have much control over. Yes, it could come back on concurrence. We ought to do the work in this House and make sure this bill is the way we want it to go out of this House before it goes over to the Assembly. So if this is a 2-year bill, the author had plenty of time to do it. Maybe I'd ask you to address that in your close, Senator Leno. These amendments that are floating around out there came to our side of the House and to our consultant at 8 o'clock last night and said, oh, well, it's all okay. So I urge a no vote. The bill's not cooked, and let's do it right.
Further debate or discussion? Further debate or discussion? Seeing and hearing none, Senator Leno, you may close.
Thank you, Mr. President. I think we all know how negotiations go sometimes. Yes, it is a 2-year bill. Yes, we've been working on it for over 7 months, and it was just this very weekend that our opposition has agreed to a negotiated settlement. So I wish I could have rushed it a little bit sooner, but these things happen in their own time. The good news is that we have found agreement. It's all in writing, and I'm happy to share it with anybody. Of course, it is on my word that the bill only goes forward with the amendments as agreed upon with the industry in the Assembly. And of course, we know when promises are made on the Assembly side, if they get to Policy Committee here and the changes that are not made, the bill isn't going to move out of Policy Committee. So I think there are safeguards in the system. And it's not just about amendments floating around. It is all here in writing. And I just want to point out that 94% of all default judgments are when someone does not actually show up in court. to be able to defend themselves. And as Senator Correa has shared with you, he was never served. But the industry knows current law requires no documentation when they get to court. So they know they're going to win, especially if they didn't serve the right person. And there's just no consequence or ramifications for their bad dealing. So what this bill will do, of course, will level the playing field because, of course, there are good actors who are doing their best to make sure the creditors get paid. We all believe the creditors should get paid and that debtors who owe the money should pay their debt. But Senator Correa should not have his finance world destroyed, if not severely challenged, because of some bad players. So I appreciate your indulgence in working through all of this with me. And just lastly to say that this will clear our very challenged, underfunded court system of frivolous lawsuits. And if we can agree to the definition of a frivolous lawsuit as a lawsuit that has no merit because it has no documentation, this will end those kinds of lawsuits. The Bay Area has seen the number of these kinds of lawsuits double in just the past 3-4 years. And in Santa Cruz County, they report that 40% of their entire civil litigation docket is made up of these kind of lawsuits, which have no documentation. So we'll clear up our courts, we'll protect innocent people, we'll level the playing field for the good actors so real debt can be collected by those who are owed it. I ask for your aye vote.
Mr. Secretary, please call the roll.
Alquist. Aye. Anderson. No. Berryhill. No. Blakesley. No. Calderon. Canella. No. Corbett. Aye. Correa. Aye. De Leon. Aye. DeSaulnier. Aye. Dutton. No. Emerson. No. Evans. Aye. Fuller. No. Gaines. No. Hancock. Aye. Harmon. No. Hernandez. Huff. No. Kehoe. Aye. LaMalfa. No. Leno. Aye. Ted Lieu. Aye. Carol Lieu. Aye. Lowenthal. Aye. Negrete McLeod. Aye. Padilla. Aye. Pavley. Aye. Price. Aye. Rubio. No. Runner. Semidian.
Aye.
Aye. Steinberg. Aye. Strickland. No. Vargas. No. Walters. Wolk. Aye. Wright. Aye. Wyland. Yee. Yee. Aye.
Please call the absent members.
Calderon. Hernandez. Aye. Runner. Walters. Wyland.
Ayes 22, noes 14. The bill is passed. Members, we have completed a first run through the Senate third reading file. Let me go back to the beginning of the file and ask those members who passed previously if they wish to take up the remaining items. Going back to file item 65, Senator DeSaulnier, pass. File item 66, Senator De Leon, pass. File item 69, Senator Leno, pass on file. File item 70, Senator Leno, pass on file. Members, I believe that completes all items on the Senate third reading file for which authors are prepared to take up the item. Let me ask one last time, are there any remaining items on the Senate third reading file members wish to take up? If not, we will return to motions and resolutions. Members, are there items under motions and resolutions? Seeing and hearing none, if there's no other business, Senator Steinberg, I believe the desk is clear.
Thank you very much, Mr. President. There will be a relatively brief Democratic caucus in the Maddie Lounge at 10 minutes after 12. Session itself will resume at 9 o'clock on Thursday morning. We have 3 significant budget-related items to take up, and so we'll see each other Thursday at 9 o'clock. Thank you.
Thank you. Members, as the President Pro Tem has just announced, Democratic caucus in the Maddie Lounge, 12:10. The Senate will be in recess until 3:30, at which time the adjournment motion will be made. Before we bang the gavel for recess, Senator Huff, members, if I could ask for your attention for one moment, please.
Yes, there's also a Republican caucus with lunch up in room 305.
Room 305, Republican caucus. Room 305, Republican caucus. Again, the Senate will stand in recess until 3:30, at which time the adjournment motion will be made. We will reconvene Thursday morning, 9 a.m. Without objection, we are in recess.